morning, everybody. Welcome to today's session, Introduction to Intellectual Property. My name is Jeremy O'Hare, and I'm an information expert here at the British Library Business and IP Centre. And welcome to our Startup Day Online 2021. Welcome to this breakout room where for the next, about 50 minutes or so, we're going to be focusing on intellectual property. So I'm going to go through a presentation here, which is going to give you the overview of all the different types of intellectual property, everything you'd want to know from an overview point of view around this subject. So maybe that'll be a spur to look a bit further into and a bit deeper into some of the different topics that we're looking at. But most importantly, I just want to reemphasize through this presentation just how important intellectual property, or IP as I refer to it, is for you and your business, especially at a startup stage for today. So just a quick disclaimer before I go on, and I'll be presenting at a pretty quick gallop all the way through. So hold on to your hats. It's going to be quite fast. There's going to be a lot of things thrown at you in this short period of time, but just bear with me with that. And at the end, we'll get hopefully 5 minutes just to open up to some Q&A. So feel free to put some questions in the Q&A box, perhaps towards the end of the session, and I can try and get to maybe a couple of those at the end. Our time is really limited. But just a quick disclaimer here, this presentation is not legal advice. And there are times where you would want to consult a lawyer, trademark attorney, whatever, patent attorney. I'll flag that up as I go through, and I'll flag some other services that we can help you with around the legal side of things. So what is intellectual property? At its most simplest, intellectual property, IP, is a protection for any kind of creativity and innovation. So we have a body of law, we have acts of parliament, which are there to protect innovation and allowing you to commercialize various different things that you create, products, new inventions and trademarks and so forth. We'll go into all of these in detail. But the law is there to allow you to commercialize this, and also to prevent others from using your creations without your permission, which is a really important concept just to kind of put out there from a very early stage. So intellectual property is like an umbrella term. It's a description which describes all of these other, what I like to call, members of the IP family. And there's 6 different members that we have, and we're going to be going through all of these different forms of IP in the next 50 minutes. So we'll be looking at patents, and that is something very specific to how something works or the process of making it. We'll be looking at trademarks. You may have heard of those. These are words or logos to indicate the origin of products or services. We'll be looking at registered design, what that actually is, and it protects the look of a product or object. And copyright, which I'm sure you've all heard of. And there are specific things that you create where copyright actually could potentially apply to you. Artistic works, paintings, books, films, music, but also things like software. There's quite a list of other forms of expression that copyright covers. And then we'll be looking also at trade secrets and know-how. And these protect special knowledge that you have, processes, techniques, practical things that you know in your business. We'll look at that in due course. So as I go through the 6 members of the family, you will find a pattern. Half of these members, if you will, are what we call registered rights, and the other half are unregistered rights. So these registered rights being patents, trademarks, and designs, that means that you need to register for protection, and you register there with a government body called the Intellectual Property Office. Really important that you get onto that website and have a look around. Even if you're just generally interested in IP, they have wonderful guides around what you need to know about IP. So I'd recommend just kind of digging around and looking at their guides. But nonetheless, if you're going to register, say, a trademark, that's who you would need to register it through. Now, the other half of the IP family are unregistered rights, and that applies to copyright, trade secrets, and know-how, meaning you don't have to register those to have protection. You just need to be able to enforce them for yourself, as you would with the registered rights, but it's unregistered is a lot simpler to start off with. So that's a distinction between the two that we'll explore a bit more as we go through. Just a quick point to make that if you're a startup, I would encourage you to set a bit of a budget for your IP. So there are some costs involved with filing, but also when it comes to growing and scaling your business, you may need to at times defend your IP. So it's good to just put aside a little bit of money where you can, in the same way that you have some money for a marketing budget for your operations, put some aside for IP spend. And that will see you well if there are situations in the future where you need to come defend your IP, because as we'll find, there is no IP police. You have to do that yourself, unfortunately, but there are ways around how you can do that. So I've got an illustration here to kind of ground what I'm talking about, these members of the family, into a company and into actual products that we use. So the Coca-Cola company has been around for well over 100 years. Not surprising, they have all of the 6 forms of IP well and truly covered and protected. So we have the logo here, very famous logo. That is a registered trademark, one of the earliest trademarks that we have, well over 100 years, still in force. The company, of course, owns it, and they can put that on merchandise. They have complete ownership over the lettering and also the logo design, which is probably, I think, one of the most valuable trademarks any company could own. So there you go. Also, there is a registered design on the bottle shape here. So this is a classic design, again, about 100 years old. About 1916, I think this was registered. And it has value in the sense that if you were to take away the logo and just see the bottle, you'd recognize that as a bottle of Coke, such as the value of the design. So we'll explore why design could be useful to you as we go through. Interestingly, there is actually a patent on the ring pull opener of the can. So all cans have this these days, but hard to imagine. But at one point in time, this was a new invention, and in the late 1960s, an inventor came up with this design, and I'm sure Coca-Cola would have paid a license to have used that little bit of technology to seal the can and to open it with a ring pull. Would have been a new thing, and they would have paid a license to the inventor to use that intellectual property in their products. So we have here on the right a nice bit of old advertising from the early 20th century. This belongs to the copyright of the company. The company owns these images, and all the marketing that they've done over the years, or the music they've created, the adverts, the imagery, the Father Christmas imagery is a famous one that comes out around about this time of year. They can reuse the stuff, they own it, they can reuse it for merchandising, maybe for anniversaries, occasions, for whatever marketing purposes it belongs to them. It's a powerful and a very useful back catalogue of assets that they can draw on. And down the bottom here is question mark. You may well have guessed this. This is the famous trade secret. What is the recipe for Coke? We don't really know. It is under lock and key. It is actually in a museum safe in Atlanta, Georgia, where the headquarters of Coca-Cola are in America. So patents are there to protect new inventions, how they work or how they're made. So there are kind of key criteria around what qualifies for a patent. So it must be new, it must be non-obvious, and must have some sort of useful application as well. So a patent should be better or cheaper or different to other inventions that are out there. So patents are granted by countries and regions, so they are territorial. So if you're going to apply for a patent, you need to think about which other countries around the world you want to have your patent enforce. And that's a really important thing. So you need to look at the broader market around what's the potential of the invention. Are you just going to get protection for the UK, or are you going to apply for protection in other countries around the world? Because they don't last forever. A patent is a state-granted monopoly for 20 years. And then after that, the patent becomes public domain. So anybody can essentially use it. So when we think of lots of everyday technologies like the zip, that was a new patent, new invention way back when in the early 20th century. That patent's expired, everybody uses zips. So the maker and inventor of that time only had that 20-year monopoly to make the most of it. So the fees on the surface here look quite reasonable, perhaps £320 plus extras. However, if you're going to apply for a patent, we'd really recommend you seek some legal professional help around that, because complicated document to write. You need to get everything correct. You need to be able to defend it, because patents will be eventually published. They'll be open to opposition, and you want your patent to last at the time that it can. So we do recommend professional help. If you try and do it yourself, the success rate, and these are stats from your IPO, is only 1 in 20 applicants actually get their patent granted if you do it yourself. So the kind of numbers do speak for themselves. However, that will increase your costs. So you'll be looking easy at £3,000 to £4,000 just to get a UK patent with legal advice. And those costs will escalate cumulatively as you go across other regions around the world. So it's something to bear in mind. Another really important thing about your invention is that you must keep the invention secret until your application is made. So don't share it with anybody, because that can potentially invalidate your application. If you have to talk to people like prototype designers, manufacturers, use a non-disclosure agreement or NDA. There's a link there for those. It's a legal document you can use, which kind of helps to protect the confidentiality of the invention. Of course, the agreement is only as good as the honorable side of the two parties, and if anyone breaks the agreement, you have to prove it was them that did. Anyway, I won't get into the technicalities of it, but it's the best form of legal protection you have if you need to divulge your invention to anybody else. Be wary of invention promoters. There are people that will say they can promote your invention, make a lot of money. That's rarely the case. Best to speak to independent advisors like ourselves, or lawyers from the Chartered Institute of Patent Attorneys. They'll be able to advise for you as well. Now, of course, the thing about a patent, it must be absolutely new, never been done before. So you need to evidence that this is actually completely new, your invention. So that's why we say that you should do what we call a prior art or novelty search. So you can look online to see if it's an invention, it could be used for a product. What is out there, look through specialist literature if it's technical invention, and then of course also look at existing patents. And you can do that on our patent database, Spasnet here, where there's over 60 million plus patents you can access. It's quite a technical thing to do. We can guide you around that through our other webinars and workshops, but I'm just flagging this up. This is an important thing you need to do, to look for existing patents. So you can kind of prove to yourself as best you can that this invention is actually new, never been done before, and therefore you can look at going for a patent. We'd also encourage you to do some market research, commercial viability around the invention itself, because as you can see, it's expensive to take a patent. You want to make sure there's a commercial value to it at the end of the process as well. Just a quick note on international filings. You can file through the World Intellectual Property Organization to cover other territories. That makes the process that much more efficient. And you'll be easily looking at £50,000 to £60,000 to get the equivalent of sort of a worldwide protection. So you have to be careful about where you select your patent protection with. Okay, so moving on to the next member of the family, trademarks. And this is perhaps something that we're a little bit more closer to home. We interact with trademarks, with brands every day of the week. We're buying products with trademarks. So the trademark is the badge of ownership, as it were. It distinguishes you and your product and service from anybody else. A trademark can protect a name and a logo, also a slogan, a shape, even a particular shade of color can be trademarked, and a sound very rarely, but that is also possible to trademark. There's like particular advertising jingles, you can get a protection on that. Now, the thing about a trademark is distinctive for the goods or services which you apply to register, and of course, it has to be completely different from any other rivals. And the key point here is that it cannot give a false impression, and it cannot be allowed to create any confusion in the marketplace. So distinctiveness is really key for your trademark. So the trademark is the sort of the registration of what the brand is. Now brand is a big topic. We don't have time to go into all of that. It's kind of distinctive to that, but the trademark is sort of the legal registered representation of the brand, be it the font, the colors, the style of the lettering, and so forth. Can I just say as well, a trademark is an asset like a patent. These are bits of property that you own. So as the company grows, as your business grows, the value of your trademark should grow with the company. So it becomes an asset that you can sell or license out as and when the business gets to the point of what you want to do with it, whether you want to sell or sell bits of the company off, whatever you choose. So you can see a trend here. A trademark, again, is territorial like patents. So you register in country, or you can register through an organization like European Trademark Office, and you can kind of get through the Madrid Protocol. You can get coverage across a block of countries. Just again, it kind of makes the process that much quicker. And a trademark is a country specific also. It can be bought, sold, or licensed. As we'll see, that's very, very important with trademarks. And it can last, in theory, forever. So long as your trademark is kept active, you can register it every 10 years, you get another 10 years, and it can, in theory, last forever. And the fees are, I would argue, relatively inexpensive. And actually, it's a bit cheaper than that. If you do an online application for a trademark, it's about £170, plus the extras, which include the classifications, the areas of industry where you want to register your trademark. We'll get into that in a moment. So a common question is, can you have the same or similar trademark as someone else? Yes, you can, so long as they are in a completely different classifications. So there's this thing called the NICE classification system. You're going to have to find out about that if you're going to file for a trademark, because it's about 40 plus different numbers, different categories you can file your trademark in. Some will cover consulting, some will cover manufacturing, some will cover service industry, some will cover different types of products. So long as your trademark is distinctive and from others in your classification, you can potentially get that protected. So the example here being Swan, same name. You can have the same name as someone else, but you look at how different they are. There'll be no confusion between Swan car rentals, electrical goods, and matches. You know, they're quite distinctive, and they will all be in different classifications there. So just something to bear in mind with your trademark. There is something called an unregistered trademark right. We have it here in the UK. Not all countries have it. It's enforced in the US and Australasia as well, where you can pretty much start trading with your mark from the get-go. You just put TM on your brand, your logo, and you have an unregistered right. Now, it's not as strong and as enforceable as a registered trademark, where you see the R in a circle. So really, registered is where you want to get to, because then you can much more easily object to anybody misusing your trademark, or you can oppose other trademarks which might be similar to yours. So a registered trademark is the way to go. But if you want to start off, get something going now, a TM is, well, we'll do just for perhaps a short term. Yeah, so when it comes to legal disputes, the TM is nowhere near as strong as the registered. So there are grounds for refusal of trademarks in the UK, just so that you know. I'll go through the last three here. Anything blasphemous or obscene, causing offense, that kind of makes sense that it wouldn't be accepted. Names of pictures of famous people or characters, well, that's a copyright infringement potentially, so that wouldn't be allowed. And then international symbols, obvious things, Olympic rings, we couldn't kind of claim usage of those. Now, the one at the top here, wording that describes a product or service, tends to be where most people get caught out with their applications. So your trademark cannot be too descriptive of what the trademark is. So by that, I mean, if I'm trying to file a trademark tasty cakes in the food manufacturing classification, so I try and trademark tasty cakes, I would guarantee that would be rejected on the grounds that it would be too descriptive. So if I change that and put another word, so like Jerry's tasty cakes, that trademark then has more of a distinctiveness to it, and there's a better chance that would be accepted and passed by the trademark examiner. So anything that is too descriptive is unlikely, highly unlikely to be passed as a trademark. And anything for those other reasons, or anything that causes confusion in the minds of consumers, it can also be rejected. There is an exemption on that. So you'll find a lot of URLs like lastminute.com. Last Minute is very descriptive. They have acquired a trademark because they've gotten market share, and when people know that the name, there is a dispensation where that can potentially be trademarked in retrospect. So that's an exemption. That's exceptional. You have to be like a seriously big player to kind of have that. Just in case you're wondering, a lot of people ask that question. So searching for trademarks is like a really important thing. Like a prior art search for patents, you need to make sure before you file that your trademark is not used by anybody else. You also do some general internet searches to make sure there's no unregistered rights potentially out there. That's the database you can use. If you do trademark search, IPO, type that in, it'll bring you up to the online register. You can look through that, do some keyword searches for your name. You can also search by images and design shapes as well. So you can kind of make sure that you, as best as you can, you're reassured that your trademark is hopefully going to be accepted. So here's examples here of some very iconic trademarks. The point I want to make here is that the visual element of trademarks can be just as powerful as the word element. So the Bacardi example here is interesting. They have a trademark for the name. It's what we call it a word mark, BACARDI. So that sequence of lettering, Bacardi, is protected, but they also have a trademark for the bat logo, which you could say is just as strong aspect of the brand as the name. You know, if you're in a bar and it's dark, you see the bat logo there. That's a very effective means of communicating the brand through the iconography. So the point here is that you can file a trademark, both the name, the lettering, and also an image as well, and or no name and just the image. So the Superman brand here is a fantastic, very powerful image, so you own that trademark. I think it's Marvel. I'm not sure. One of the largest studios owns the mark. That's almost a license to print money, because they can license out that image to merchandisers, makers of stuff. They pay a fee to use that, to use the image, and it's a very, very powerful trademark. So yeah, words or images, something to think about with your design if you're gonna go down that road. Speaking of design, moving on now to the third member of the IP family, we have registered designs. I'm not going to spend a lot of time on this, but this is more for those of you that are designers that want to protect either a packaging or a product which is designed. It's a three-dimensional form, but design can also cover 2 dimensions, so wallpaper design and so forth. Generally, anything that is can be manufactured on a large scale, or even on a small scale, can be protected by registered design, whereas a one-off piece, say a work of art, will be protected by copyright. That's the distinction we can have between them. So there's an industrial application to registered design. So as we've seen, the countries specific and regions, like trademarks, like patents, they're property. You can buy, sell your design. They don't last forever. There's a cutoff point there in terms of the timing around trademarks. And the application is relatively kind of straightforward, online, relatively inexpensive, £60, and then you can file a series of designs for reasonable cost, to cover different aspects of whatever design it is. You can look on a database here for existing trademark designs. We also have other webinars that can help you with that. So here's some example designs. One in particular, the tuning head of the Fender Stratocaster is registered design, because the look of that is so iconic for that guitar maker. The sunglasses here, Ray-Bans, the monkey mascot, which is for ITV. So if you're going to sell monkey toys, you want to own the shape of that to make sure no one else manufactures and makes monkeys, and that rightly belongs to the TV channel. So this is where a design is very useful. Interestingly, not quite so used in the fashion industry. You think it would be, but because fashion is such a fast moving market, seasons change and looks change, and you can get inspiration from one design and create a new design and so forth. So registered design is not such a big thing. Pieces like jewelry or iconic footwear, let's say, might be protected by design, but certainly areas, as I said, product packaging or toys is a big area where design is useful for. So the Star Wars Stormtrooper helmet is a registered design because it's such a strong, iconic visual thing. It makes sense that Lucasfilm would register that as a design. So anyway, you get the picture there around where design could be useful for you. Now, copyright, let's move on to this. This is a really fascinating area. And by the way, you know, as you saw with the Coca-Cola example right at the beginning, you can have multiple forms of intellectual property. You can have a portfolio even in your small business. So it's most likely that you might have a trademark. You should have a trademark because it's going to be your business name. It's going to be your brand. And then there'll be elements of copyright that you create, your web pages, for example. And it might be that there's something that you're making which you can get a design coverage for. So do see this as a menu of options depending on whatever the creation that you have in your business. One of these forms of IP may well potentially apply to you as well. So copyright here protects works of art, paintings, books, films, music, and also other things like software, because software is considered like a written text, a string of letters and numbers. If we've seen with other forms of IP, you can buy, sell, and a big thing around copyright is licensing it out to other people. So it's different to other forms of IP in that there is a time period, well, like similar to patents and designs, there is a time limit to it, but the difference is in the years involved. So copyright lasts quite a long period of time. It lasts 70 years after the death of the creator, 70 years, 70. So copyright can be passed on, it can be in estates. Families can own copyrights of their deceased relatives. The Tolkien estate owns the copyright for his work. Picasso estate manages his copyright because they have died within 70 years. George Orwell, his works are now out of copyright because he died just over 70 years ago. This is the year that his work becomes available to reprint, reproduce, do films, theater, whatever. So we mentioned copyright is an automatic right. As soon as you create it, it's yours. You don't have to register it. It's free and instant. So here's the thing. You need to be able to prove that you own the copyright to it. So what we recommend you do is that you put a C in a circle. I'm sure you know the sign very well. Put your company name or your personal name on the work. And you need to record the date of creation in some way. And there are methods to do this. One is the good old fashioned post your manuscript to yourself in the post, register post in a sealed envelope. So you make sure that no one, that proves the date, make sure no one can open the envelope. And that's sort of like a proof of date. I mean, I've never known it to be tested in a court of law. A better option might be to file with an IP attorney. They have archives, they would do that. There are ways now where you can timestamp digital files. So there's a service called WIPO Proof from the World Intellectual Property Organization, WIPO Proof. You can, buy a tag, for 18 Swiss francs or whatever. So you can timestamp your digital file, just because software can be easily manipulated with timestamps and things. So just to kind of be aware, the point here is that it needs to be admissible as proof that you created what you did. So it's all about getting to your creation first and being able to evidence that before other people. So that's super important. Otherwise, it's an automatic right. And there are treaties across the world around copyright. So other territories respect each other's copyright rights. So it's managed by treaties. And just a quick screen here to expand what copyright covers. All of these things, but films, video, TV, radio, broadcast, engineering things, technical, architectural plans. We mentioned promotional literature, advertising, and there's a related right called database rights for copyright as well. So when it comes to ownership, if you're the owner of the work, you actually get a lot of rights as a copyright owner. You just have to be able to enforce them. And this is an important thing. The way the owner can enforce and monetize their rights are through licensing. That's the bridge to making money. So you can license your novel out to a Hollywood producer, or you can sell your rights and you get something back for that. You can sell the rights to your novel to a publisher, and they'll take over from there and manage your work. So you have the ultimate say. So you have to make sure that whatever deal you do with your work is appropriate to your needs. I just want to make a very important point here around freelancers and creators. So this is often a pitfall many people fall into. And this is good news if you're a freelancer. Be aware, if you're a freelance designer, photographer, whatever, you own your IP. So just because someone pays you to do work for you, let's say to take pictures of products for someone's website or to design a logo, you own the IP. So the flip side is if you're commissioning someone to do your logo, they will own the IP. So you need to ask them to assign the IP to you. Likewise with photographs and other things. So if you're a freelancer, you have a lot of rights. So, so it's up to you to manage that. So make sure you have a contract, and call it an assignment of IP. If you're an employee, the employer, full-time or part-time, the employer owns the IP. So this slide deck that you have today, I'm an employee of the British Library. The British Library owns the copyright, and quite rightly too, as well. So there you have it. That's a situation in law. So people can often assume that they own something because they pay someone to do the design for them. That's not the case. So there are exceptions to copyright. People always ask this: what can I use of other people's? So my advice to you would be best to assume you can't until you can prove otherwise. And the exceptions in the Copyright Designs and Patents Act are such. They are listed here. Very specific things: copying for non-commercial research or private study, quoting for critique or review. So, if I was to quote someone in this presentation, absolutely fine. The world is an information world. We need to quote other people for knowledge to be shared. That exemption is allowed for. But where you're starting to use substantive amounts, and there is no definition of what that is, by the way, where you start to perhaps step on people's toes around usage without either crediting them or getting their permissions to use, then you're potentially in danger of infringement. So best to err on the side of caution, get permissions from publishers, owners. There are ways, websites where you can find out the owner of say, photographic works, literary works, and so forth. Always err on the side of caution, especially around images. Actually, because everything's so easy on the internet to get, you cannot assume that the image is out of copyright. Most likely that it is not. Other reasons, exemptions here, visually impaired users, time shifting for personal purposes. This does move me on to Creative Commons, because this is an interesting area of copyright where you can use images under or software under Creative Commons licenses. The point still stands though, that Creative Commons is still a license. The owner of the photograph is still allowing you to use that work. It may be that the license is very, very generous, and it quite often is. You can use it without having to pay a royalty or a fee. You can adapt it for commercial purposes. But the point still stands: a Creative Commons license is still a license, i.e. the owner, the photographer, is pretty much volunteering all of their rights over the work for anybody to use. But you need to be careful, because there are different types of Creative Commons. There are different variations. It might be that you need to, for example, credit the work of the photographer, for example. So that's very important. The principle of licensing still stands. Open source is a form of software licensing whereby you need to make the source code freely available to everybody. So copyright, again, to come back to that point, if you're the owner of it, it gives you a lot of rights: the rights over copying, adapting. So, anyone that wants to adapt my novel for a screenplay, they have to get permissions. Anyone that translates my novel, there's still an ownership issue there. I need to have some form of acknowledgement or permissions, and maybe even a royalty if my work is translated. Publishing rights, there's a similar right to there. If you're publishing something the way that the book is laid out, there's a separate right, just so that you know. Where a work is rented or performed, the creator should get some sort of royalty and fee for that, and there are organizations that manage the rights of copyright holders, particularly in the music industry. They're called collecting management organizations, CMOs. They will manage that side of things on behalf of the rights holder. Broadcasting rights and things as well. And if you're a performer, if you're a voiceover artist, you have some sort of rights and law around, you've been able to be recognized as such and being able to be paid for your work. There are producers' rights in the music industry. So these things are all kind of part and parcel of copyright. I should add, there are other things called moral rights. So that means that if you're the creator, you have a reputational right over your work. So, where your work has been misused or you've been misrepresented in some ways, you have that backup in the law to object. And we see that a lot, actually. This happens every time there's a big political campaign. Some politician will use like a a famous tune, from an artist or a band, and the artist or band will object to say, I don't want to be associated with this political campaign, because my moral rights are infringed, essentially. So that happens a lot, and so that proviso is there in copyright law. There's other related rights, sort of database rights. I won't get into the weeds with that. It's quite a complicated right, but that effectively protects the way information is managed, how it's, and also using other information. You have to be careful around rights, around other people's data and so forth. Complicated area. Don't have time to go into that, but just so that you know, that's an area to maybe explore if you need to. So that's copyright in a nutshell. I'm keeping an eye on the time. We're doing pretty well. So I'm just coming to the last two of our members of the family here, know-how and trade secrets. Now, a trade secret is that kind of secret recipe stuff. And so let's imagine that, you have a recipe passed on from your great-great-grandmother for the most delectable, perfect chocolate brownie you could imagine. And that's kind of just passed down through the generations. So that's a trade secret. You wouldn't be able to get a patent on a recipe because there's a very high bar around novelty. To get a patent, it's more likely that you would get protected through trade secrets. The brewing industry, is full of trade secrets, and it's a very easy right to manage. You just have to keep your recipe safe, make sure you manage that within the company. You only have certain numbers of people, and if you have to disclose, say, with the manufacturer, you have confidentiality agreements firmly in place, and that's where you might need to get the help of a lawyer to help you draft that very, very kind of tightly and very, very specifically. So as long as you can keep the secret, it's fine. If someone else has the same secret at the same time, well, you can't do much about that. It's just an unfortunate coincidence. So know-how, as we mentioned with the Coca-Cola example, are the things that you know in your business that give you a competitive advantage. It might be a process, it might be a network, let's say. And I would encourage you to think, if you're starting out, what are the things that you know? Are you really good on SEO optimization? Are you really good at sales? Whatever you're good at, see that as know-how, because that will be the thing that might give you a bit of an advantage over other people in the same, starting up in the same area. But don't think of it too selfishly. You can also exchange your know-how. So in the network, if you know how to do something really well, and someone else has got maybe they've got a really good knack at marketing, and you've got at designing websites. If you the more networking you can do, you can kind of help each other. And with that skill set, so trade on your skills, trade on your experience. If you're in retail, really, you can go into retail in particular products. That experience is something that is very valuable. So think about what you've got in terms of your know-how, and as time goes on, your business will acquire that and will give you really, in a way, a time advantage over anybody else trying to get to market as well. That's another thing too. So it's a kind of a balance that you have in your business. So I just want to kind of conclude really there with sources of information. And just a note, I realize it's startup day, and the topic today really is sustainability. So whatever you have in terms of your environmental focus for your business, it may well be that you have a technical innovation. And that's where a patent might easily apply. So there's lots of industries at the moment which are innovating in all sorts of new and interesting ways to bring down carbon emissions, lots of interesting technologies around that. I was reading the other day that the concrete industry is a massive creator of CO2, and there are new sort of biological agents in the manufacture of concrete which can kind of help reduce emissions. That's a new technology coming on stream, so there'll be patents most likely around that side of things. I read as well the aviation industry, electric engines. I wouldn't have imagined this, but that's really seriously been looked at. So in the next decade or so, we may start to see some early engines which use battery and therefore should be cleaner in terms of its emissions. That's been seriously looked at. So there'll be new patents off the back of that. There won't be long haul flights, but they'll be sort of under 800 kilometers short, medium haul, which is actually half the airline industry is short to medium haul flight. So there you got two examples there of where there'll be technical innovations and where something like patents would be involved. But whatever your business, you've got a beautiful green brand, you want to have that trademark with a logo. If you've got some really environmentally friendly products, you want to get that, maybe the shape of it protected through a design. And likewise, whatever your content you're creating, words for your website, the images you're creating, the overall appeal, the impression you're creating can potentially be protected by copyright as well. And don't forget your know-how. That might be the thing that kind of keeps you going. That's our email, bipc@bl.uk. If there's any kind of questions or queries that you have off the back of today, send us an email at that email, bipc@bl.uk, and we'll get to your query. And there's a whole bunch of services. We do run IP one-to-ones where we can. We try and upload those every week or so. They're very popular. They're called IP clinics. Just to flag up that there is a huge range of commercial information that you can access here at the British Library. So if you want to do the commercial research on your patents, you could use us, lots of market reports, over £5 million plus of market data, huge valuable resource that you can access. You can do that by obtaining what we call a reader pass. So you need to bring along proof of your address and signature, like a bill bank statement in the last 3 months through the post, and that will be your proof, and your signature, of course. Driver's license is really good because you've got that proof already with the address. And then you can get a reader pass, and you can come up and use our resources, speak to one of the staff here on the inquiry desk. We can make this a little more personal. We can find out more about you and your background and what it is that you want to do from your research. And this will be very interesting information that you can use for your business plan, or just basically for your strategy. The more you know about the market you're going into, the opportunities, the better. And likewise, we can help you on doing the trademark searches, on the patent searches in particular. We can help you on that. We do have other webinars which run, over the month, over the few months on designs and on copyright. I run that webinar on copyright, on patent searching. So you can dip into those and get some really more in-depth information from those webinars. And likewise, there's the one-to-ones. Just drop us an email, get in contact with us, and we'll help you as best we can. And I think the thing with IP is it can be a bit overwhelming and a bit confusing. So my hope for you in this time and the time that we've had together, my hope is that you have a much clearer understanding of where you sit with IP and what the potential possibilities are, that you have this menu of options. You got some sense of where the costs may be and where there are actually no costs, where you need to enforce things, and where you can look at really seriously commercializing your content. Because at the end of the day, intellectual property is an asset that you own in the business. I can't emphasize that much. It is a property, you own it in the same way that you sell a house, you rent it out, you buy it even. So your IP is property, it's an asset, and it's going to be potentially an integral part of your business and part of your revenue and part of your growth. And if you choose to sell, no matter what you do with your business, getting it right early on at startup days, so getting it right when you start up, is super important for your future prospects with the business as well. So my name is Jeremy O'Hare. Again, I'm the information expert in intellectual property here at the British Library. Absolute pleasure to have time with you today. I'm sorry I aren't able to see you or to hear from you. I can only trust and assume that you can hear me and that you've gotten some value from today's presentation. And feel free to get back to on the email address just there, bipc@bl.uk, and we can follow up with you from there. I will stop share and I'll now hand it back to our team at Unique Media for the next presentation coming up, I believe, in about 5-10 minutes. Over to you guys.